Morning, folks. We're just waiting for Mr. Harwood to come back, and then we'll get started.
Good morning to everybody. Happy Wednesday. Today is Wednesday, the 26th of February. This is a continuation of our case that we have been ongoing thus far. It is the hearing for the consolidated cases by Goodnight, Midstream, and Empire, New Mexico. It's the various case numbers. I'll just read them again real quickly. Case numbers 24123, 23614 through 17, 23775, 24018 through 24020, and 24025. Yesterday, when we left, we went into closed session. Our closed session is over. We are now back in open session. And I know we have some things we need to discuss, so I'll hand it over to Mr. Rubin.
Thank you, Mr. Chair, and let the record reflect that the only things discussed in closed session were those stated in the motion and that no final actions were taken. We came back at about 5 o'clock. We had lost our video feed and our court reporter, so it was like a tree falling in the woods. So we are officially now back in open session this morning. I suppose if someone accused the commission of sleeping during the closed session, they would technically be right. So, two issues this morning. The first deals with and this was a matter of some contention by Empire, most recently in their renewed motion regarding the scope of the hearing. And we have revisited and reconsidered that especially in light of the testimony and evidence we have heard in these first 2 days. And so, as a brief refresher, the July order signed by former Chairman Fuge had the scope of the hearing regarding evidence, testimony, and legal argument on the issue of the existence, extent of, and possible interference with the residual oil zone in the EMSU by produced water injections activities undertaken by Goodnight. Well, that is clearly not the proper scope, in my view, of this hearing, and I will in a few moments ask for a motion to that effect. But as stated by counsel for both sides, the issues are more broad than just what is in the ROZ. Any correlative rights that Empire or any other operator would claim as impaired would be something that this commission should consider, as well as waste, and it should not be limited to the ROZ. Also, in light of OCD's position regarding the potential concerns about drinking water, we are also mindful that the scope of this hearing should encompass what by statute directs the commission to consider with respect to the disposition of produced water. So, and I'll get to the practicalities of this in a few minutes with each of the parties, but if I could have a motion by the commission to amend paragraph 2 of the order I just read from dated July 2nd to say, at said hearing, the parties shall submit all evidence, testimony, and legal argument on whether the granting of the applications by Goodnight would, 1, impair correlative rights or cause waste pursuant to section 70-2-11, or 2, result in the disposition of produced water in violation of the Federal Safe Drinking Water Act or otherwise fail to protect public health, the environment, and freshwater resources pursuant to section 70-2-12B-15, and whether the granting of the applications by Empire would prevent the impairment of correlative rights or waste pursuant to section 70-2-11, or 2, prevent the disposition of produced water in violation of the Federal Safe Drinking Water Act or contrary to public health, the environment, and freshwater resources pursuant to section 70-2-12B-15, and to the extent that this revisits and modifies the previous denial of Empire's order, so be it. Empire's motion, rather. So if I could have such a motion?
I move.
I second.
And if I could have a vote? All those in favor?
Aye.
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 Okay. Any opposed? So with that, I want to be very mindful and considerate of what the parties have done up till now and make sure that what we are proceeding with is going to not, if to the extent we are changing course, I don't want to prejudice anyone. My sense of it is that the witnesses we've heard are laying a foundation for what should be the proper scope as stated versus as opposed to what we had before. And the case we're hearing really, I think the case that all the parties are preparing is the case that is better captured by what we now have as the proper scope. But that is not for me to say, that is for you all to say. I know we have our witness for this morning, and I'm hoping that perhaps at least, not to put Empire on the spot, but what I'd like to do is have you all think about this, and perhaps after lunch, we'd want to hear if there needs to be any God forbid, recalling of witnesses if necessary, but reordering of witnesses or so forth. But for now, Ms. Shaheen, I believe this was your.
I'm sorry, Mr. Rubin.
It's okay.
I was distracted there for a moment.
No, and I'm sorry. I should have waited for you to finish. I believe this is the witness you were handling the direct on.
That is correct. And we did have one question about the motion
Yes.
and the scope. And is it still limited to the EMSU?
No. If there are, I mean, the statute does not limit this commission in any such way. If there are some other correlative rights that are being impaired or waste, we need to hear it. I think we'd be surprised if it reached outside the EMSU, but certainly we're hearing potential testimony about drinking water and the Capitan Reef, for example, that's outside the EMSU. So certainly that would be the case.
Okay, thank you.
So with that, I don't know if you are in a position to say at this point whether we can continue with this witness as we had been up till now, or if based upon what you're hearing this morning, you want to, again, if there needs to be some sort of reordering or reassessment of what witnesses are called and when. I mean, we weren't going to finish by Friday anyway. So I don't think we're changing horses in midstream too dramatically, but I will want to hear from the parties on that. Do you have any initial thoughts, or if any?
If I may have a minute to confer with the client?
Sure.
Okay, thank you.
Absolutely. And then when we come back, we do have the second issue of the pending motion to quash a subpoena.
I apologize, Mr. Rubin. Is it possible for us to have a 10-minute break to discuss further?
Of
with the
course.
clients?
No, I apologize for having to make a motion at this after 2 days of testimony. So absolutely.
Thank you.
We'll take, if that's okay with Mr. Harwood? Okay.
Absolutely.
So we'll take a 10-minute break.
we are going to be missing the hearing officer. He has trials, so. So-
Yeah,
Not override. No. We want to.
Ms. Shaheen, are we back?
We are ready to explain our
Okay.
position.
So let's make sure that our court reporter is on and that we're back on record.
We're back on the record.
Awesome. Thank you, Madam Court Reporter. Mr. Rubin, go ahead.
well, okay, so if I'd like to hear from the parties, and we'll start with Empire.
We would be interested in Goodnight's position, but what I can say at this point, one is we would like to have clarification as to whether the applications relating to the other wells that have been stayed are now being incorporated into this proceeding.
That is not the intent of this order, no.
And so we are prepared to go forward with what we have, but we will need to be able to have an opportunity to supplement our testimony to include information related to the EMSUB and the AGU.
Understood. Okay. And we will sort that out in a reasonable process with all the parties. So then if I could hear from, I guess we'll go to Goodnight.
Mr. Rubin, I don't know that I can possibly state my position right now because I don't understand what the commission's position is or what the announcement on I just don't know what our position is because I don't understand the potential scope. I know what the applications are that have been filed. I know what the issues were up to this point, but I don't know what the implications are of what I've just heard. You know, I put up a map of the 3 units or this unit and all the offsetting disposal wells. You know, we're talking about 60 SW, more than 60 disposal wells. None of those operators have any idea that their injection into the St. Andrews is potentially at risk. And this is the issue that I raised back in May or June when we had this initial scope hearing was, and the reason to limit it to the EMSU was to manage the scope. And I understand there may be broader implications. And of course, with respect to the Safe Drinking Water Act, there are outside potential impacts.
Mm-hmm.
But I'm gravely concerned about how this redirection and the scope of the hearing could play out. And I don't understand, frankly, I just don't understand what is being changed and what the implications are. So
Thank you, Mr. Rankin. I can tell you this. We are limited still to the applications that are before this commission, not the state applications. I believe your opening argument stated, do these applications impair quality of rights or cause waste? That's the issue, as you put it. That remains the issue. Now, we are not unstaying anything else. This is all the parties who wanted to be in this hearing are in this hearing, I presume. And this is not, nothing in what's happening this morning changes that at all.
let me just give you an example of why I'm concerned. Okay. Up to today, this morning, we understood that there's 4 applications to revoke that Empire has filed. Goodnight's saltwater injection. And those wells are limited to the EMSU. Okay. The applications to revoke assert only that the EMSU is being impacted. Okay. What we've been hearing all we haven't been addressing because we don't think it's relevant, is that there are these other wells miles away in the MSUB and AGU that are potentially, in communication. We haven't been addressing that because it's not within the scope of their application. It's not within the scope of the order before the commission. And I cannot allow that to be broadened without addressing it. Now, if that becomes part of the scope, I need to go get our guys to go do another, months of research to evaluate these additional allegations that are just, being tossed into the hearing. And that's gravely concerning to me, and I cannot allow our case to go forward with that on the table.
Well, Mr. Rankin, as I understood the applications, the applications that are being heard, they are generally limited to the EMSU. And if there were any, if the parties have, it would be surprising to me, based on what I've heard, that this somehow changes the complexion of the case. To the extent there are other rights outside the EMSU that were implicated by these applications, that should have been part of this case. If you feel like these applications that are being heard now affect rights outside the EMSU, shouldn't the commission hear them? That is what their statutory obligation is. So I am concerned about what you're saying. I'm not sure if it's just a lack of, if we're just simply not on the same page yet about this. So let's move on and let's at least hear from the other parties for now.
Maybe just make a fine point of it, because I would like to know. I'm very sensitive to. I want to know what their plans are, what they're going to allege. Okay, and if they're saying that based on the evidence presented today, that they're going to come around and say, well, we've demonstrated that there's impairment of appellate rights in the EMSUB and the AGU, without showing any. I just want to know what's on the table, because I don't right now anymore, and I want to be very clear about what the disputes over.
Okay. Well, and my concern is that if Empire is somehow not allowed to put on any evidence of impairment to its correlative rights caused by the granting of your client's applications, that is a problem. And I think you'll acknowledge that. And the scope was incorrect in that respect. We had previously limited this. We had limited it not just to the EMSU, but to the ROZ, as the parties are going to hopefully define it for us. I did not see an issue between taking it outside the EMSU to the extent that it's still limited to whatever these applications would or would not cause harm to. Okay, don't know if we're going to resolve this at the moment. If we could hear from, let's go to OCD.
Thank you, Mr. Rubin, commissioners. So it's OCD's understanding of this case that it involves injection and production from the EMSU, and then the impacts of that, which covers OCD's interest in the Safe Drinking Water Act. That's why we got in the case, was our interest in the EMSU. I am also concerned about enlarging the scope. I'm far from naive about the ability to conform pleadings to evidence and other legal doctrines that can certainly apply to these things. But this has been, frankly, a slog, and this would also require at this point, and I don't want to do this, further evaluation by OCD2. If we're going to start incorporating multiple other units, I do think on one hand, there's room for this discussion on appeal. I also think that if we're going to expand beyond the MSU, it would have stood to reason to see amended applications and other documents along that line. So OCD has concerns about expanding the scope outside the EMSU, especially because even if there were, and some of the documents I know that probably birthed this issue visibly were ones that came out rather late in the entire process. I believe it came through some of Empire's rebuttal witnesses, and that, that starts to look a little sneaky, to be quite honest. OCD has already pointed out tactical disadvantages that, there's no blame to be cast here. That's not OCD's position. But the way procedure has gone, it created problems for OCD to be able to accurately and effectively rebut the cases of the respective parties. And I think this goes beyond that potentially. And so there's a level here of concern, because I do think, not to be the bearer of bad tidings, I'm not sure there's a good decision either way here, because ultimately this is going to result in another appellate issue on top of what I'm thinking are legion at this point. So that's OCD's position for the record on this determination.
Before we go back to Empire, anything from Rice?
Yes, Chair, Commissioners, I agree with most of what Goodnight and the OCD said. I think this is just a huge invitation for error. For the last 6 to 8 months, everyone has been operating under the order that you just amended, that this is limited to the RAWs, the existence of a RAWs, evidence of a RAWs. Now, the parties certainly have changed that position over the 6 to 8 months, and everyone anticipated we were going to talk about the Safe Water Drinking Act and the impact of injection and production in the EMSU, the possible impact of that on the Cap 10 reef under the Safe Water Drinking Act. So as Mr. Moander said, I mean, there are certain times where you can conform the pleadings to the evidence. What no one anticipated before 30 minutes ago, and what I don't think anyone can have any idea the impact of, is changing the order that was put in place in June or July that this is limited to the EMSU. Certainly Rice and Permian would have a different position. They would have had the ability to bring in evidence. They would have had the ability to go get their own experts, because they do have interests, as I mentioned in the opening, outside of the EMSU that they may want to protect. And as Mr. Rankin brought up, I anticipate that some of those other 60 injection well operators in the region would have the same thing. I think that everyone anticipated, just like Mr. Rankin said at the beginning in his opening, that we would be talking about correlative rights and waste. That's this commission's prerogative. That's its mission. Everyone recognized that, despite what was limited in the order of the scope. But without, I mean, as Mr. Moander brings up, you're creating a huge appellate issue without everyone agreeing at the outset to an amendment. And Rice and Permian certainly can't agree to an amendment that extends this beyond the EMSU. So that's Rice and Permian's position. Is we would certainly object to what I understand is the second part of this order, that it's changing the limitation of this to the EMSU.
And okay, appreciate that, Mr. Beck. Is someone here from Pilot?
Yes, Mr. Rubin, good morning. Miguel Suaza with Beatty and Wozniak on behalf of Pilot. I'd like to echo the concerns expressed by Goodnight and Rice and OCD. I think, we would need time to assess the new order. As Rice has said, we've been operating under the order that was issued this past summer. I think that Pilot would need time to, process the language in this amended order and then determine how its interests are impacted. Pilot has significant interests outside of the EMSU with only a marginal interest in the EMSU itself. If this order is amended, Pilot would need to, very seriously reevaluate and likely take a much larger, role in this case, because its interests would be impacted. And so I'd ask that, as quickly as possible, the commission could circulate the order that it proposes amending the scope of this hearing under, so that we could evaluate how this impacts our interests and changes the nature of our position and role in this hearing.
Let me ask this of Empire. Is it the position of Empire that these applications by Goodnight, if granted, would impair any of Empire's rights outside the EMSU? Okay.
Yes.
Okay. And, okay, given that, is there, if you would, I'm sorry, go ahead, Ms. Sheen.
Just to clarify, Empire objects to expanding the scope of the hearing at this time because it brings in further delay. And the more delay we've had 2 years of delay now. If we have more delay, this is only going to result in the damage to the reservoir continuing and effectively impacting Empire's correlative rights. If we wait any longer, and to that end, we're willing to go forward now with what we have, so long as we can come back soon with additional information related to the MSU B and the AGU. If there's any further delay, we respectfully request that the commission suspend the authority of Goodnight to continue injecting in the existing wells.
Okay. What I'm hearing first and foremost is taking this outside the EMSU is what is the problem. That seems to be what I'm hearing. And is there, my concern was we were hearing lots of evidence about impairment of above the St. Andrews and the Grayburg, and there would be non-ROZ rights that would be impaired by this. That was my focus. So if the parties are still good with limiting this to the EMSU, then that was my misunderstanding. Is that, let me ask, good Mr. Rankin, he raised his hand. Is that a fair statement?
Mr. Rubin, thank you for clarifying that, being that you're concerned, because I believe that the parties have always understood that whether or not injection into the St. Andrews was causing impairment or potentially waste in the Grayburg was always understood to be a core element of this case.
Okay.
In the EMSU, okay, that was always understood to be a direct issue.
Okay, well, that is good to hear, because I was trying to conform the order to that understanding. And my ignorance then, I thought the applications, the scope of this was by the nature of the applications limited to the EMSU. But if that is the case, it sounds like it's appropriate for the commission to continue to limit this to the EMSU. If we do that, but otherwise amend the scope as stated, are the parties copacetic with that?
I guess I need to see the language of the order. I would need to see the language of the order. But my understanding being that the scope is being clarified to define the impact, the scope of the hearing to include potential impacts within the EMSU, correlative rights, waste, not limited to whether there's an ROZ or hydrocarbons in the St. Andrews, but any impacts within the or waste within the EMSU, right?
Yes, that was my intent. Also, not to forget the concerns of OCD also be incorporated into the scope of the order, with respect to the disposition of produced water.
Understood. And from my perspective, Mr. Rubin, commissioners, is that whenever there's a UIC application, the scope of the consideration is always on impacts to USDWs is always on the table. So that's not a material modification in my view of the scope of the order or of the hearing.
Thank you, Mr. Rankin. Before we go back to Empire, Mr. Moander, is that consistent?
I think that's right. I mean, I understand the desire to see the language of the order, but if there's agreement that the subject matter stays within the EMSU and then the impacts of production and injection, which I think is what we're doing here, OCD would be perfectly fine with that. Something else that I did want to note here is that if there's any further effort to expand the scope, that I think that also wanders into due process violations and notice requirements for other operators, which actually snowballs this into something considerably larger almost instantaneously. So I wanted to throw that out there, but okay. I will pass the mic over to Mr. Beck.
Chair, Commissioners, I echo exactly what Mr. Rankin and Mr. Moander said. I think that if that's the limitation of the change of scope, as long as we see the language, I think that's something that Rice and Permian can consent to.
Excellent. Shane?
We are fine with the scope
Okay.
as described by Goodnight. I would just note for the record, this is only about Goodnight's injection, and it does not relate to any other saltwater disposal operator.
That is correct. Yeah, it's Empire's applications to revoke those authorities. Yes, that is understood.
Thank you.
Okay. Yes, I don't want to forget about Pilot. Mr. Suazo, any further thoughts before
Yes, Pilot can agree to the limitation that this all pertains only to those wells in the EMSU and these specific applications, with the caveat that we would like to review the amended order language and have the opportunity to come back before the commission to express any additional concerns or issues that the client might identify. So I think, yeah, with this limitation, it should be fine, but we just want to see the language.
Okay. With that, anything further from Empire? I would like to restructure a motion for the commission, unless you have anything further, Machine.
Not from Empire.
Okay. So, commissioners, it appears that the previous motion, I need to ask for a motion to modify that, to limit it to the EMSU. So let me restate.
There's more.
I want to make sure that the impacts from injection and production in the EMSU is included in that, because that's OCD's case.
Yes, I mean, to a certain extent, Mr. Moander, you're asking us to fix what we needed to fix anyway. Yeah. Okay, so, Mr. Chair, members of the commission, let me restate what should be the proper scope of this hearing as per an amended paragraph 2 to the July order. At said hearing, the parties shall submit all evidence, testimony, and legal argument on whether the granting of the applications by Goodnight would, 1, impair quote rights or cause waste in the EMSU pursuant to section 70-2-11, or 2, result in the disposition of produced water in violation of the Federal Safe Drinking Water Act, or otherwise fail to protect public health, the environment, and fresh water resources pursuant to section 70-2-12B15, and whether the granting of the applications by Empire would prevent the impairment of qualitative rights or waste in the EMSU pursuant to section 70-2-11, or 2, prevent the disposition of produced water in violation of the Federal Safe Drinking Water Act or contrary to public health, the environment, and freshwater resources pursuant to section 70-2-12B15. With that, before I put this motion to see if I have a motion, is that consistent with what we've just discussed?
I believe so, Mr. Rubin. I believe so. Again, I would like to just, because I'd like to see the order, but I believe that's the case.
I'm going to step in here just 1 second. I say we take a 15-minute break. We write something up, the motion, so everybody can see it. It's not just verbal.
Okay.
Then you all can confer on that. I think that would be the best, and I think it may ease a little bit of the tension in the room right at the moment. So why don't we take about, actually, we're going to do a half-hour break. Let's reconvene at 10:30, and we'll have something written up for you all, and then we can all discuss. Thank you. Okay. Sheila, are we back online?
Yes, we are.
Okay, Madam Court Reporter, are we back on the record?
Yes, we are.
Excellent. So we took a 30-minute break. I believe the order was submitted to everybody, and you've had a few minutes to review it. I'll turn it over back to Mr. Rubin, and the conversation can continue.
Thank you, folks. I do see that there was one typo. There should be a number 1 in the 4th line from the bottom before the word prevent, to be consistent with the 1 and 2 tracking in the first part of paragraph 2. So with that, I'd like to hear from the parties if I got this right. Start with Mr. Rankin.
Yes, I think starting at the beginning here, I think the way that it's been drafted at said hearing, the party shall submit all evidence, testimony, and legal argument on whether the granting of the applications of Goodnight would, number 1, impair collective rights or cause waste in the EMSU pursuant to section 70-2-11 encapsulates our understanding. Okay, so any evidence on communication or impairment or waste potentially outside of the EMSU, I think my understanding is not cannot be used to demonstrate waste impairment outside of the EMSU. Okay, number 1. Number 2, or result in the disposition of produced water in violation of the Federal Safe Drinking Water Act, or otherwise fail to protect public health, the environment, and freshwater resources pursuant to 70-2-12B15. That also reflects our understanding of the Commission's ultimate authority and jurisdiction to always address Safe Drinking Water Act under its jurisdiction and primacy, as well as these other requirements under the Oil and Gas Act. The next section here, and whether the granting of the applications by Empire would, with the modification to include number 1, prevent the impairment of collective rights or waste in the EMSU pursuant to the Oil and Gas Act. Again, that's our understanding because it's limited to the EMSU. Okay. Now, the other part, I think, the last part here, or prevent disposition of produced water to the end. I don't believe that's in Empire's applications. And I was just in the middle of pulling them up because I don't believe they're seeking that relief or have made those allegations. I believe that, and Mr. Miranda can correct me if I'm wrong, but I believe that the division's concerns about potential impairment of safe drinking water, I think also applies to Empire as well as it does to us. But I'd defer to Mr. Miranda. I'm in the middle of pulling up their applications, but I don't believe that they're alleging that in their applications.
Okay. Mr. Moander, what are your thoughts on that point?
So in taking a look at this, and I appreciate the effort. I recognize what, we're trying to get this taken care of quickly. I can say that paragraph 2, and I guess it would be the second paragraph 2 that does not appear in the application. I'm not seeing that in the Goodnight applications either, or just the drinking water reference at all.
Well, it's implied in it's part of our application to show. See what I
And that's so that's contained within the orders that Goodnight relied upon. So I feel like that's not necessarily an accurate presentation because we don't have evidence or that wasn't pled. But I think ultimately the intention, I'm assuming here, on behalf of the OCC is to outline what the basically claims are, obligations are of the party, whatever the claims of each respective party. So those could potentially stand alone in here. So I've had a little reservation on the second paragraph of 2 because that wasn't pled or part of that record. But that would be my only gripe at this point, Mr. Rubin.
So what I'm hearing is from both of you that taking out paragraph, the second after number 2 at the end there would be to your satisfaction, both of you.
Yes. Okay. That's my proposal will be to delete, and I'm happy to put it on a screen, but yeah, delete the second number 2 in reference to Empire's applications, because yeah, they do not allege, they allege solely that they should be revoked. Revocation will prevent the waste of recoverable hydrocarbons and will protect correlative rights. There's no allegations that that there's any impact to the Safe Drinking Water Act.
Okay. I'm certainly here. I'm glad we certainly revisited the order of July 2nd regardless, because this is not what that said, clearly. And there were avenues for appeal if we did not fix this. So, okay, I think I have some consensus there before we get to the pilot and Rice Empire.
Thank you, Mr. Rubin. Commissioners, I'm still wrapping my head around this, the implications of removing number 2 from the scope of our applications to revoke. I think that the issue is pertinent, and that if there is disposition of water that is contrary to the Safe Drinking Water Act, that our applications to revoke should be granted. So I hesitate to suggest that that issue does not pertain to our applications to revoke.
Okay.
Regardless of whether it's pled or not. I think under the obligations that are imposed on the commission to protect drinking water, that issue would go to whether our applications to revoke should be granted.
Fair enough. Okay, then, I mean, I'm trying to get a consent order here if I can, but I agree with I tend to agree with Ms. Shaheen.
Yeah, I just want to raise the point that I don't know how they're going to get a CO2 recovery project if there's communication with underground sources of drinking water. You know, they're going to have the same problem. Okay, they want to inject under a UIC program into the San Andres for EOR recovery. And they're at the same time saying that there's communication with a protectable aquifer. It makes no sense. So I think they do need to understand, and maybe they need to take the time to understand what the implications are, but it's not in their application. And the division, as I understand, has the same concerns about what Empire is doing in the same in the same formations as what Goodnight is doing.
It seems to me, without getting into the substance, that if Empire's applications are to revoke, they should encompass the same issues, the ones being sought by Midnight. It seems as a logical conclusion that they should mirror each other. That if Goodnight and Empire, one seeking to revoke, the other one seeking approval of the same thing. And we are doing this. I included this mostly in deference to OCD. This was an 11th hour issue, and we do want to make sure that if the commission rules on that basis, that a district court can't say, hey, that was outside the scope of what the parties were preparing. So I'm inclined to leave it in. But I'll ask again if it does it give you, will I get consent, or do I need to just do the motion without consent?
Well, I don't know. I don't know that I can agree because it's not in their applications. So, I mean, I think it's covered in the order and the scope of the hearing because that's something that's required to be shown by our applications. But I don't know that I can agree that it should come in as proposed because it's not part of Empire's applications.
Okay, fair enough. Let me hear from, and appreciate all your cooperation and courtesy on this. We'll hear from Mr. Beck and then Mr. Suazo.
Rice and Permian are aligned with the OCD and Goodnight.
Okay. And by OCD, Mr. Moander, I take it that you agree with Mr. Rankin that should not be included at the end?
Well, the issue is that a revocation is distinct from granting an application, and that the Safe Drinking Water Act, that's part and parcel of the granting of the permit. That being said, the more we discuss this, which of course is always dangerous with a room full of lawyers, is that what we're looking for in this case is spreads across all the operators, almost regardless of what's going on. We need to determine what is actually happening vis-a-vis the San Andres and the EMSU and the Capitan Reef. I I think that perhaps what needs to happen is splitting off that second number 2 into an independent angle on the scope, where that OCD is looking to protect or evaluate the protection of safe drinking water and underground sources of drinking water, something like that. Because Empire's application is for revocation. Now they could demonstrate a violation of the Safe Drinking Water Act. That's perfectly within their purview. But I'm not seeing where that is inherently necessary to the revocation. You see what I'm saying, Mr. Rubin?
Yes, you'd like this to read where that paragraph 2 with respect to both the Goodnight Empire application would be separate.
Yes, I think that
Okay.
that should resolve it. And I'm happy to have that sort of appended to OCD and what they basically OCD needs to investigate and then potentially enforce the Safe Drinking Water Act in
All
a
right.
form like that.
Ms. Shaheen?
Thank you, Mr. Rubin, commissioners. I think that Empire is in agreement with Mr. Moander's proposal.
Good. Okay. That wasn't too hard. Mr. Suazo, I don't believe we've heard from you.
Yeah, thank you, Mr. Rubin. I've reviewed, I haven't had the chance to confer with my client on whether or not, specifically including the Safe Drinking Water Act in the context of the order covering the proceeding, gives them any concerns. So I would like to take the time to do that. I think for purposes of today, in terms of the witnesses we have in front of us, it, is fine to proceed. But, without giving my client the chance to really review and assess how this change might impact Pilot's interests, I'm inclined not to take a position on the order as proposed.
Then let me do this. Let me suggest that we continue with the hearing. I think we have an agreement, we're close to an agreement in principle. I will rework this and email it to the parties over the break. And then we will revisit this and make sure, because I want you all to have something in writing before you say yay or nay. That's fair, certainly. And in the meantime, may I suggest we then continue with, we do have one other matter this morning to take up, and then we would continue with this witness. Yes, Mr. Chair.
Mr. Rankin, I apologize. I just wanted to see and hear from you. We heard from Empire that the modification that the OCD suggested is something that Empire could potentially work with. I don't think we circled back to you. If the modification that the OCD suggested to this to this motion was something viable to Goodnight, obviously, I'm sure you need a second to think about it, but I just wanted to make sure that we caught your thoughts about that modification as well.
Yeah, I mean, maybe I'm sorry to belabor it, and I don't mean to. I wonder if it may be helpful. Well, my understanding is that as part of Goodnight's requirement to make a showing under its application, the way that the proposed order is drafted is correct, because we both have to show that it won't impair collective rights or cause waste, and that it's protective of safe drinking water or drinking water supplies. Okay. So I do think the way it's drafted is probably correct. But I guess I'll wait to see how it looks based on Mr. Rubin's proposed modifications. So without belaboring that point, I guess I'll just wait and see what it looks like, and then we can confer after we see the language.
Okay, so but you don't have massive objections right at this point.
No, I don't. I mean, I think we all agree that assessment needs to be part of the scope of the hearing, and the question is just whether how it's properly portrayed under the order.
Okay.
Yeah.
So as long as I was just making sure that we didn't have any massive objections on that aspect, then I think we should proceed as you stated, Mr. Rubin, and then we go from there.
Thank you. So I will look to your emails over the lunch break, and I will have a new version to you then. In the meantime, Mr. Harwood, as I think we've stated, he had to step out probably till the lunch hour. He had to attend to another matter in district court. So I will hopefully run this as the well-oiled machine no pun intended, that he has been doing so. So with that, the next order of business is there was a motion filed by Empire to quash the subpoena that we issued on by request of Goodnight for, I believe, the CEO of Rice. I don't want to advise the commission on this until there's been an opportunity for some to be heard on it. We'll start. It's your motion, I believe. Ms. Harvey?
Yes, thank you, Mr. Rubin and commissioners. We did file a motion to quash Goodnight's subpoena to the CEO of Rice. It was issued late last week after all of the deadlines passed for disclosure of witnesses and testimony. The rule on pre-hearing statements, which I've cited in the adjudication provision, expressly requires a party to provide, and this is a quote, the names of witnesses the party will call to testify at the hearing, and in the case of expert witnesses, their fields of expertise. Goodnight never identified any witness from Rice as a potential witness in this hearing. And so it's late. The request was also submitted to the commission ex parte without notice to the parties. We weren't aware of the subpoena request until the subpoena was issued. And finally, the testimony of a Rice representative is not relevant to the issues here, as we've just discussed the scope. Rice operates wells that are not the subject of this hearing, and those are not at issue. Rice also is a party in this case and has not identified any of their own experts or witnesses to testify. So it's an improper subpoena request. It violates the scheduling order. It violates the adjudication rule. It's untimely. And Empire would be prejudiced because at this point, we have no idea what this witness proposes to say or what testimony Goodnight seeks to elicit. So we would ask that the subpoena be quashed.
Thank you, Ms. Harvey. Mr. Rankin.
I haven't had a chance to even read their motion. So I haven't even had a chance to read it, but I can respond to what she's saying. The adjudication rule that we're operating under here says, quote, the director or the director's authorized representative shall, upon a party's request, issue a subpoena for production of books. I'm sorry, I'm reading the wrong portion of that provision. Here we are. The director or the director's authorized representative shall issue a subpoena for attendance at a hearing upon a party's request. Shall. We provided notice to all parties in our pre-hearing statement that we were intended to seek and issue a subpoena for the appearance of witnesses at this hearing. We included Rice, Pilot, Empire. There were four potential parties that we identified that we would likely seek subpoena for appearance of at this hearing. So we gave them notice that we were likely to do so. That came about. It became apparent that it was important to do so based on Mr. Beck's opening statement and the documents that he provided as part of his pre-hearing statement. The evidence that we intend to elicit from Mr. Curtis is highly relevant to the issues in this case, including they've been operating in this unit for 60 years. And he has some documents that reflect what the early pressures are for the unit, what which are important, I think, for the commission to hear and see. So while their wells are not directly implicated by Empire's efforts to revoke, the evidence and testimony that he's would provide are highly relevant. And so we think it's absolutely important, and it's the obligation of the commission in its quest to determine whether there's impairment of correlative rights or waste to hear that evidence and to see it.
Mr. Rankin, a question for you. You said that you did provide notice to the other parties of your intent to subpoena witnesses, including, did you specify Mr. Curtis?
I didn't know who it would be, but I found out from their pre-hearing statement that it would be Mr. Curtis based on the document. So I didn't know who the witness would be.
And was that notice to the parties provided before or after the deadlines in the scheduling order?
Well, it was provided with the pre-hearing statement when we filed that because, so we did not include him as a potential witness in our initial witness disclosures or rebuttal witness disclosures. No.
Okay, which came afterwards?
I'm sorry, what was the question?
The disclosures pursuant to the scheduling order of your witnesses and rebuttal witnesses came after.
After what? Just so
After
clear.
you claim, after you state that you did provide some notice that you were intending to call a witness, Mr.
I'll just be real clear. So the initial witness disclosures were, what were they, in August?
Okay, that's what I thought.
Yeah,
Right.
and then the rebuttal witness disclosures were in January. The pre-hearing statement was in February. As the case has evolved, you know, I couldn't, you know, force Mr. Curtis to come except by a subpoena. So I determined that it was necessary to do so based on my understanding of the evidence. Now, the rule provides that the commission shall issue a subpoena for attendance at a hearing upon a party's request. And that's what I believe should be done.
Mr. Chair, members of the commission, before I offer any advice, should you want it on this, you do have the obligation, of course, to go into closed session to debate the merits of this motion. I don't know if that is the sense of the parties, or, and I've noticed this commission tends to not go into closed session unless it has to. So what are your thoughts? We'll start with the chair. Do you wish to go into closed session? Do you want my advice on the motion? Have you heard enough?
May I just also just make a point? I mean, I have not had a chance to review Ms. Hardy's motion. I've been preparing for this hearing day to day. If there's any indication that you're likely to grant the motion, I would ask for an opportunity to respond. It's not imminent that this witness is going to appear. We've requested for him to appear only at the end of Goodnight's case in chief. So if the commission is interested in hearing or would prefer a full argument on the issue, I'm happy to oblige and provide a full response so that we can properly respond to it. I haven't even had a chance to review it or read what her arguments are.
In light of that, Mr. Rankin, how long would it take for you to prepare a response?
I may look to my colleague on my right here to help me put it together because day to day I'm working on preparing cross and preparing our case. So, yeah, I mean, if next week would work, we can do it sometime by next week, middle of the end of next week.
Okay. And it sounds like we're not going to get to your witnesses before then anyway.
Right.
Okay, fair enough.
I think that's the best. So, Mr. Rankin, go ahead, write your response. And then we as a commission will consider it at such time. In addition to, we'll have both so we can make our decision with full information. So if you wouldn't mind doing that.
All right. I see that Mr. Harwood is back as our hearing officer. Mr. Harwood, are you ready to reassume the reins?
Yes, I'm not sure where we are.
So
I will fill you in.
We didn't get very far, Mr. Harwood. We got a lot done, but not exactly on the case. And poor Mr. Burkett has been sitting on this witness stand waiting for all of us to deliberate stuff. The only thing that I did want to mention to you, Mr. Harwood, I did mention it to you earlier, but everybody, I do have a hard stop at around 4, latest 4:15 today. So keep that in the back of your minds with the questions and stuff. So Mr. Harwood, Mr.
Yeah, it's Harwood.
It is Harwood. I said it right. Now we turn it over to you, and we're basically just picking up where we left off yesterday before we went to closed hearing.
Okay. All right. I just remind the witness you're under oath as you were yesterday, Mr. Burkhead. I'm not sure who was questioning the witness when we broke yesterday. I guess I should have guessed it was you, Mr. Rankin. So you go ahead and pick up where you left off.
That's a good question. Where did I leave off? Okay, good morning, Mr. Burkhead. It's been quite a morning.
Yeah, I was gonna say, is it still morning? That's
It's been quite a morning. My head's still spinning. So I think we had left off, back and forth discussing some different aspects of your opinion and underlying issues relating to your opinion in petrophysics in general and Mother Nature's water flood and so forth. So I'm going to do my best, I think, to pick up. I think what I'm going to do is just kind of pick up where we had discussed or touched on some issues or questions, and I in the intervening time have wanted to just follow up with you on a couple questions, mostly related to the inputs and assumptions that went into some of your petrophysics work, and then we'll go back into your testimony. I'd asked you yesterday about whether or not you had prepared any permeability curves as part of your analysis, and you told me that you did, that you used standardized curves that are in the literature, and I don't even recall the author who had developed them, but there were three different permeability curves that you had used in your analysis, and that you didn't generate them yourself, right?
So the perm curves that I created were based upon Dr. Jerry Lucia's model, who Dr. Davidson references a lot within his testimony. Okay. And yes, I did generate the curves using my interpretation, but they were standardized curves that Jerry Lucia created based on separate rock types within carbonates.
Now, I'm asking about this because I don't know that the output of your the application of those curves was provided to us as part of the materials provided to Goodnight. Is that something that you would be able to export and provide to us?
Easily. If it wasn't exported, it was just an oversight.
Okay.
I'm happy to provide that.
Then I would ask that Empire Council coordinate with you to ensure that we have those curves and the outputs so we can review them, because we haven't been able to do that to date.
Okay.
Okay. We had talked yesterday about the oil formation volume factor, B sub O. I probably got that butchered. B sub O. Now, we talked around that a little bit, that it was provided to you by Empire. And I wanted to, if you know off the top of your head, you know what the value was that you used?
As I said yesterday, 1.3.
1.3.
Yes.
Okay. Okay. And that was the same B sub O factor that you used throughout your interpretations throughout all depths, correct?
The B sub O is only used within the roll up of the oil in place calculation.
Right. Okay. We talked yesterday about how you were calculating the baffles, right, in your petrophysics. I think, and I wrote this down, but I wanted to make sure I understood it. It was a summation of the horizontal porosity is what allowed you to calculate the vertical perm. Is that right? Close or not? Not even.
Not even.
Okay. Give me another shot.
Okay.
And tell me how the porosity is used to calculate your vertical perm and your baffles.
So I did not calculate a vertical perm from this. So what I did was using the Lucia model, I calculated 3 different permeabilities based upon the porosity. The baffle was created using a simple cutoff of 1.5% effective porosity. And that was to be as generous as possible because we do see continuous porosity across the majority of the section.
And is that applied within a certain range of depth? I mean, in other words, is that an average effective porosity over a certain range of depth? How are you?
It's a flag.
Yeah.
It's a flag that's shown wherever it is below 1.5%, 1.5 or below.
At any like half foot increments, or how? What is
it's at the step of the well data, which is generally a half foot.
Half foot. Okay. So whenever a half foot interval meets your effective porosity cutoff, then you'd get a baffle flag.
Yes.
Okay. On the matrix you assigned a 2.9 matrix value. Is that right? In your
That's incorrect. So Mr. Bailey was partially correct when he said that. I used a variable grain density in order to account for the addition of anhydrite cements. For the dolomite portion of the ternary diagram we used to calculate the mineralogy, I used a 2.9 grain density there to account for up to 20% anhydrite cement, as again being generous, and the rest of it was, I believe, the limestone was left at 2.71 and sandstone at 2.65. So it was a variable grain density, and what you'll note is, or what you can note looking at my curves versus Dr. Davidson's, is that the fit is very good.
Okay. So it wasn't a uniform 2.9. It was 2.9 and then 2.7 for the.
No, it's a variable grain density. It's using the neutron density and PE curves to calculate a variable mineralogy, and then also a variable grain density for the porosity.
Okay. Before I get back into your testimony, I wanted to kind of cover something else as well, sort of as a preliminary matter. And this kind of relates to some of what Mr. Bailey was testifying about yesterday, because I heard him say several times that the base case, your low case, is your petrophysical model tied to the core, right?
Yes, the core data is a cloud, so it is the best tie to the most reflective core data.
When you explain to me what you mean by the core data as a cloud.
There is a distribution of core saturations as you go vertically from depth to depth that does not match the log data. So because we know that oil and water are both flushed out of the system and then and that the water is replaced into the core and then flushed again in some cases when it gets to the surface, we get a large variability, especially when we have residual oil or residual water in the measured oil saturations, measured water saturations, which I think everyone will, I imagine rhetorically, everyone would agree we're seeing a large variation. So what you look at is because we, as Mr. Bailey stated yesterday, I think Dr. Lindsay said it as well, the measured oil saturation in the core is the lowest possible oil saturation in the reservoir. It's probably going to be something higher than that. So what I did was I used the outer limit of the measured core oil saturations to tie the data to. It doesn't always fit, but that's petrophysics. You fit it the best you can to the maximum of the minimum data for the low case.
Now, my question then is, because you only have limited core data into the San Andreas, upper part of what Empire identifies as the San Andreas, how do you then correlate your logs to other deeper intervals where you don't have core?
What do you mean? Did you
calibrate? Calibrate. How are you calibrating, or how are you interpreting your logs when you don't have that core in corresponding depths?
The information, the typical petrophysical method in looking at this data is to use the calibration data you have and the mudlog data and all the data I showed during my rebuttal. It helps to inform your decision. So in the wells that I showed, they have oil saturations and trace oil, streaming cut, oil on the pits. There is recognition of oil below the Lovington sand, which is generally where the core was taken, was Lovington sand and above. So beyond that, what petrophysicists do is they don't make big assumptions on changing the model if they don't know that it changes. So where we have core, we match the model. Where we don't have core, we use the same model unless we learn something different.
Okay. So yeah, in addition to mud logs, you would also look at well tests, production tests, other empirical data that would help inform your analysis, correct?
I think I looked at one production bit of information. It doesn't, because we're talking about residual oil, right? The definition of residual oil is it doesn't move.
Well, yesterday we talked about the definition of residual oil being within a range of 20% to 40% oil saturation.
No, we didn't. We talked about it being between 20, somewhere below 20. We don't know what that value is exactly, and around 50%. As a gauge, as a guide, we don't know exactly what it is until we know what the fluid is and the pore types and the wettability.
Okay. But we thought and you understood that the wettability was mixed wet to oil wet.
Yes, correct.
Okay.
Mr. Burkhead,
Yes.
this is the court reporter. Can I get you to slow down just a little bit?
I can try. Sorry.
Thank you.
I know. I just wasn't sure where the voice was coming from. That's
Okay. Moving back to your exhibit L, I'm looking down on page 3 in paragraph 10, and I've highlighted a passage here or a sentence that I want to just discuss with you.
I'm sorry. Could you share your screen?
Yes.
Thank you.
Thank you. I was having some problems with my Adobe again, so I had to reopen my. Okay, here we go. Can you see it on your screen now?
I can. Thank you.
So in paragraph 10, I've highlighted a sentence here that I wanted to just discuss with you that relates to what we were just discussing. You state here that core residual oil saturations are lower than the in situ value due to degassing and flushing by water-based mud, and then you have citations. And I think I just want to clarify a couple of things. Number one, when you talk to in situ value, you mean whatever the actual value is in the reservoir prior to extraction, right?
That is the in-place reservoir volume. Yes.
Yeah. And my question then is, if you, I understood you just to say that residual oil by definition is immobile, how much do core saturations actually need to be adjusted for an RZ where residual oil is by definition immobile?
It's immobile in its current state. When it changes its state, then all bets are off as to how the mobility will change. There is a small amount of gas associated with the fluid. As you're moving it up, it would start to degas, and as Dr. Davidson put, it will help to eject the water, and it will help to eject some of the oil too.
Mm. Have you undertaken a study to evaluate how much conventional core needs to be corrected in a ROZ?
I have not, nor has Dr. Davidson. He just used a rule of thumb from ARCO.
Have you reviewed Mr. Davidson's rebuttal testimony?
Yes, I have.
And did he use a rule of thumb in his rebuttal testimony?
He did.
Did he verify his rule of thumb in his rebuttal testimony?
He used some data from another field in a different well, a cord well, to try and justify his correction.
And did that correction fall within the rule of thumb that he applied?
I did not look into that correction that deeply.
Okay.
It was a very long document that I got 2 days ago.
Oh, just 2 days ago?
Yes.
Okay. So you have no opinion on Mr. Davidson's?
No, I know he used data like I did. He used a rule of thumb, as I did, for an area. The ECHO paper that I reference talks about residual oil matching. His talks about residual oil matching. Okay. So, and I don't see much of a difference.
Okay. Do you have an opinion how much conventional core needs to be corrected in the EMSU here?
I believe it was probably around, this is by the seat of my pants guess of what my normal correction was, but it was probably around 10 saturation units.
What do you mean by 10? Can you put that in a different context?
If we talk in percent, it's going to get really confusing because we talk about saturation as a percentage anyway. So a saturation unit is 1 SW percent. So,
okay. I'm sure Mr.
It would be so for example, it would increase from 20% SO to 30% SO.
That would be a 10 saturation unit.
Yes.
Okay. Okay.
Yeah, as I showed in my testimony with the The diagram from Core Labs from 1973 in the depleted oil reservoir, the corrections can be quite a bit higher than that. So up to 18 to 20%, 18 to 20 saturation units.
Remind me what you're referring to there. In what instances would it be that great?
That was when the in situ core saturation, according to the diagram from 1973. So I'm taking into account this is not the area that we're talking about. The saturations of depleted oil were 30%, and when it was brought to the surface, the saturations were 12%.
Okay, and then in that context, was it addressing a residual oil zone?
Depleted oil would be the closest thing you could get to a depleted to an ROZ.
Depleted oil from a water flood or from primary production?
That'd be probably from primary production.
Okay, and that's actually very different than a water flooded field, correct?
If it's residual oil, it's residual oil.
I thought that the whole concept about Mother Nature's water flood, that it was analogous to a post-secondary water flood reservoir, not at the end of primary production.
It is the residual oil that is left in the pores. So
are you familiar?
So what I'm saying is that the diagram showing the from 1973 showing the correction is a possible correction.
Okay.
That was shown by them. That's what happens when you bring it up to surface. What the correction I used was based on residual oil from that paper, which was less of a correction than what they showed.
But just to be clear, the correction from that paper was at the end of primary production?
I would have to go back and look at that. They described it as residual.
Okay. But I thought you were telling me it was at the end of primary production during.
No, the paper from 73.
Yeah.
I'm assuming it was possibly from primary production. The one from this one mentioned, I do not know if it mentioned primary production or water flood.
Okay.
I would have to go back and look.
I'm sorry. I'm just getting confused by what papers were referencing.
A lot of papers around.
Yeah. Okay. But so it sounds like there were two papers, and one was from 1973 that addressed a conventional core correction that, in that case, it was at the end, it was in a depleted field, correct?
So that's a depleted, yes. That was the information that was given.
Okay. But it's not clear, as you sit here today, that it was in a field that had been subjected to any period of time of water flood, secondary recovery.
That information was not available, or I don't recall it.
Okay.
I will go to Seminole Field and all those studies with sponge core, pressure core, and just the conventional core, and show that those corrections are well within speed. Those corrections are well within line of the kind of corrections I'm doing.
Okay.
And mine are probably slightly conservative to what they're showing in the Seminole papers.
Okay. On that, what's the range of your corrections for your high case? If you can give them to me, like what is your correction that you're applying?
So the high case is based upon the corrections.
I understand that. And so
so as I mentioned, yeah. I'm to throw a number out there because it is going to vary. It's going to be about probably 10 saturation units.
Okay. So the correction that your model applies on the high case it varies, but it's in the range of 10 saturation units. Is that fair? Okay. How much higher than 10 saturation units do your corrections go on your high case model?
I would have to look at statistics for that.
Okay. But that would be in the information that was provided to Goodnight to evaluate, correct?
Yeah, you have my high case and my low case water saturation. That would be what you would refer to.
Okay.
As well as I'm not sure if I included the core data or not, but the equation is definitely available for use.
Okay.
Along using a V sub O of 1.3.
Yeah. I think, forgive me, I don't mean to retread, and it's probably because you were talking fast, and probably because I'm a layperson and not a petrophysicist. But I know I did ask this question, but I want to make sure that I understand it. Okay. And the question is, because you don't have core down to the base of your logs, right? How are you varying M&N where you don't have the core? And I know I asked that question, but I want to make sure I understand, because I don't actually recall what your answer was on that. I want to make sure I understand it.
You didn't ask about M&N.
Okay,
So
okay.
I'm happy to talk about
Very
it.
good, very good.
So
yeah, as to M&N specifically, how are you varying the M&N in the deeper intervals where you do not have the core?
So the Fock-Munn equation, it was I believe I can present the equation for it. They're based on 3 different rock types based upon permeability ranges. So I gave a fairly conservative permeability range. I applied a 2.3 minimum M based upon the data that has already been collected or used by other entities to do petrophysics in the San Andreas. Then it varied upwards from there, which is typically based upon porosity.
How about the N value?
The N is a little bit more complicated because that is entirely based upon wettability, saturations, saturation history, things like that. The way that I varied it was by finding a good match to starting off with the baseline. The variation can go from about 3 to upwards of 9. In reality, the saturation exponent can go up to about 21 in some carbonates. So this is a somewhat conservative value as well. Then I applied that to porosity, made a porosity algorithm to match it to the core, that matched to the core data. And then I adjusted that algorithm to a nonlinear function to match to the corrected core data. Okay. So the range is still the same regardless.
And now you did have the new tech data analysis in front of you, and do you understand that you did have the new tech analysis, right?
I did have it. It wasn't, yes.
Okay. And do you understand that they varied their M&N with depth based on a Department of Energy study that identified ranges of M&N values in 4 counties in Texas?
I believe so, yes.
Okay.
I seem to recall that.
Okay. And you agree with me that your approach here is different than what New Tech did?
Different. Yes.
Okay. And that results in different oil saturations with depth in your analysis compared to New Tech's analysis?
It would.
Yeah. And next page here, I think in this paragraph, paragraph 12, you're talking about and evaluating and assessing Dr. Davidson's approach. And in general, you're criticizing Dr. Davidson for his interpretations with depth. And here I'm going to I'll read into the record. You cite in the portion that I'm highlighting here. In other wells, we continue to see a suspicious interpretation change happen just above Goodnight's top of San Andreas. Interpretation of the RAWs, as shown by Dr. Davidson, shows a change in interpretation methods driven by their deeper pick of the Grayburg base and a presumption of much poorer reservoir quality, parentheses, rock types, over most of the San Andreas. And then you cite to your exhibits L5 through L8. Mm-hmm. Did I read that right?
Yes.
Okay. What do you mean when you say suspicious? What do you mean by suspicious?
You usually don't see blocky shifts and saturation changes through reservoirs when you have continuous porosity and resistivity. Especially not from ROZ level saturations to non-ROZ level saturations within just a few feet.
Okay. What is your understanding of the basis for Dr. Davidson's shift in his petrophysical analysis where you see that change?
Although he was somewhat vague within his description of what he did, but from what I understand, he described a facies type based upon a very slight shift in gamma ray. And with that slight shift in gamma ray, showed that it chose a stock value for what the resistivity index should be for that rock and placed it in the waxstone range, packstone range, or at least the non-ROZ range of saturations. From that point on, the resistivity doesn't matter. It will just calculate a very high water saturation regardless.
What do you understand the basis for the shift in gamma ray to be, or the change in gamma ray to be?
From speaking to Bob Lindsay and from his experience in the field, I understand it to be arcoustic sands.
Do you have an understanding what would change in the sands throughout those depth intervals?
There's generally potassium that would occur with some of the feldspars that are within the rock.
Okay.
Gamma rays also seem to vary for multiple different reasons. So it is unfortunate we didn't have a spectral gamma ray in the field.
But that's your understanding of Dr. Davidson's model. And do you have any understanding for what would influence the gamma ray with depth other than our caustic sands?
Well, you have three options. You have uranium, thorium, or potassium. So any combination of those can adjust it.
Okay.
So, all those sources can come from many different things.
Okay. Now, I kind of want to just touch on this table. I think you did address this to some extent in your summary. I think it took me a little bit, but I think I understand what you're doing here. But if you wouldn't mind, just take a quick moment to explain again what this table is showing.
I'll definitely give it a shot. So I believe that what I did was I took my low case numbers and calculated an original oil in place in MMBO, millions of barrels per section. And that is what's shown on the leftmost numeric column. To the right is the high case for that, meaning that the answer is most likely somewhere between the low and the high case. To the right of that, I have the Goodnight numbers that were given within Dr. Davidson's testimony. Within that testimony, he gave which I presume is based upon his curves, were 6.9, 13.3, so on and so forth. These were based upon the tops that Goodnight provided us for their top of St. Andrews. When looking at from the perspective that their top of St. Andrews pick is incorrect, we see that the oil in place for even Goodnight's interpretation increases significantly.
And that's this column here, right?
That is in that column there.
Yeah. And the difference for that increase is simply because you're moving the top up to OPS's top, right?
Yes.
Okay. And because you didn't break up Goodnight's this interpretation, you just put it all in all St. Andrews because I'm butchering that question, so I'm not going to pursue it. But I think I understand what you did. Because Goodnight did not follow OPS's top picks. You couldn't partition upper and lower St. Andrews as you did.
I didn't want to presume that. No.
Okay. But your understanding is that Goodnight's not injecting into, well, you didn't address that, so I won't bother asking that question. In this next section here, paragraph 15, I think you start getting into your analysis here. You state that we see in the interpretation of the wireline as well as shows and mudlogs and core for the available wells that the RZ zone consistently appears in the same intervals with oil saturations greater than 20%. This suggests large amounts of continuity across the interval. Did I say that right?
Yes.
Okay. I guess my question to you is I don't see I'm talking about your exhibits here. I don't see where in your exhibits you've demonstrated that the oil accumulations that you've identified are correlated across the intervals.
I was asked to rebut Dr. Davidson's testimony. I was not asked to present evidence for that.
Okay.
So what I can say is that when you migrate oil into a system, that's a great sign of continuity. Having water everywhere is just the status quo. But when you have oil in several wells across a large area, you can assume that there is some level of continuity across for the migration pathway.
Are you saying that you're finding oil saturations and that those oil accumulations are mappable across those intervals within the San Andres?
I have not gone through that step, but we can say that we commonly see within the San Andres oil saturations.
Okay. Then I guess I misunderstood what you're saying here, because I thought I understood you to say that you're finding consistent oil accumulations across, I guess when you're saying across the interval, you're talking about the entire San Andres.
Yes.
How many feet thick is the San Andres?
It can vary, but up to 1,500 feet in some places.
Okay.
Where we have core, it's the upper San Andres, which is, of course, not as thick as that. So
you're saying that you haven't yourself then gone in to identify whether the oil accumulations, the discrete oil accumulations that you've identified that exceed 20% are actually across the same correlatable intervals within the San Andres.
Yes, I have not gone through and done that. What you can see, though, is that above the Lovington Sand, you commonly see the same expression of an ROZ.
Okay, so that, but and that you're talking about above the Lovington Sand.
Above the Lovington Sand, yes. Okay. I can't speak to the large amount of ROZ I found below as to how that correlates across the field.
Okay. So here in paragraph 19, you state that there are several pieces of evidence pointing towards the existence of multiple continuous ROZs in the upper and lower San Andres as discussed in this document. Of course, you're referring to your statement, right?
Yes, and the context of that is in a vertical sense.
Understood. Now, on that point, I believe you were here for Dr. Lindsay's testimony.
Yes, all of it.
All of it. Did you hear Dr. Lindsay testify that it would be unique to have a situation where you have more than one ROZ or a single ROZ extending across composite boundary intervals?
I remember there being a long discussion where that was, I believe, discussed that there could be towards the end. The discussion changed where he agreed that there could be.
Are you aware of any ROZs anywhere in the Permian Basin or elsewhere where there's multiple ROZs across different formations?
I have not looked at the data with that in mind.
Okay. So as you sit here, you're not aware of any that you can point to?
No, because I haven't looked at those wells.
Okay. I'm just going to share with you what Empire is marked as Exhibit C1, and this is from Mr. Melzer's testimony, and it's what I think Mr. Melzer, and he can correct me when he gets up, perhaps, but my understanding is that this is presented as the sort of classic residual oil zone profile, showing where you have the main pay zone above, and then you have the residual oil zone below the oil water contact. And as you go down through the residual oil zone, you get decreasing oil saturations until you get to the base of oil saturation. Is this your understanding of generally sort of classic RZ profile?
That is the typical expression. And I just would remind you that this is exactly what is displayed in the depleted oil zone case in the plot I was showing.
What exactly was displayed?
Oh, it's when you showed when I showed the 30% to 12%. So just as a reminder that this is likely expressing something similar to that.
30% to 12%. I'm not
From
is
the
this
core,
today
I'm
or
going
another?
back to the core corrections, and it was from earlier, a few minutes ago.
Okay. Just so I'm clear, because I'm not exactly following you. Explain to me how that's the case with this exhibit.
It's showing a residual oil zone below a conventionally produced oil zone. So you will have, as it's produced, you will create residual oil. You'll produce it down to a level where the oil cannot move anymore.
Is your understanding that what's in this, it's your understanding that what's in this ROZ is what has been produced? What's remaining post primary production?
Yeah, and according to this plot, I do see now that it says a naturally swept interval. So if that would be naturally swept as in water moving through it as the oil was produced from the top. Would be my interpretation of the chart.
Yeah, that's my understanding too.
Okay.
Right. Okay. So this is naturally swept. And my understanding from the literature and Mr. Melzer's testimony and Dr. Trentum's testimony is that a residual oil zone following Mother Nature's water flood is comparable to what you would see at the end of a secondary water flood. Is that your understanding?
It could be. I'm not an expert in that.
Okay, so you're not familiar with the ROZ literature or how to compare Mother Nature's water flood ROZ to a post-secondary recovery water flood?
I have the data that I have from the calibration of the core saturations and from reading the literature of Trentham and Lindsay and those. Okay. Can I speak to that? There is increased production after secondary water floods. Yes. How much is it? I can't speak to.
Okay. Would you agree that this classic RZ profile is not that your oil saturations that you've identified in your wells in aggregate do not match this classic RZ profile?
If it's a conventionally produced oil zone, then it shouldn't. This would be a much higher porosity, typical. Well, actually, this is San Andreas than it would be. No, because this is for one porosity. This is not for an entire, this kind of plot is made for one porosity with one capillary pressure or many capillary pressures along depth. So this may not be for the same kind of rock that we have in the ROZ that we have here. This could be for 14% porosity rock. If I look at it again, if it's a, say, 5% porosity rock, it would look significantly different.
How about if I cut off this conventionally productive oil zone portion of this and just ask you whether your oil saturations in the logs that you've interpreted, would you expect them to match this portion of the ROZ curve?
In the high case, they would be around that level. In the low case, they would average around the 30% range.
Let me rephrase my question then and ask you to ignore the saturations at the bottom and just concentrate on the profile. Okay. I'm asking you, wouldn't you expect in an ROZ to see higher saturations at the top of your ROZ interval and lower at the bottom?
With Mother Nature's water flood, not necessarily. And I'm not sure that we have the resolution and the resistivity to actually see that with the variable M that we have. There is potential that since there's multiple charges, that a lot of things can be happening.
Okay. Now, you told me that you haven't reviewed extensively the literature around Mother Nature's water flood ROZs, correct?
I've read through it. I can't say I'm an expert on.
Okay.
Dr. Trentham and Dr. Lindsay have been doing it for a very, very long time. So it might be a good point to bring up, if you can go back to that that same chart that you had before, that I'm getting asked several times about the oil saturations and why they get up to 50%. Residual oil saturation is inverse to porosity. The lower porosity you have, the harder it is to produce, the more oil sticks to the pores, and the higher percentage of the oil is in the pore. The higher porosity it is, the more it gets flushed and the lower your saturation is. So if you look at my curves, what you'll see is that saturations of about 50% are all below about 8 to 10% porosity. The saturations that are above 10% are all around above 10 to 20% porosity.
So how does that work if you want to go in and flood it with CO2? How are you going to get the CO2 to go in those tight pores when you've got lots of other preferential pathways?
That's not my expertise, but I know in water flooding, they can mitigate that pretty easily.
Have they been able to do that in the MSU?
The Love paper suggest I'm trying to remember back to the Love paper, as I'm not an expert on that either, but I believe the purpose of that paper was to show the increase in oil production after mitigating that.
You're not aware of what the projected high case or low case or what the actual water flood recovery is for the field, are you?
Absolutely not.
Okay, so you don't know how successful any of that was, do you?
I say that from the conclusions of their paper, they said that it was improved significantly, is what they said.
Okay.
I believe.
But you're not an expert in evaluating recovery of oil saturations from CO2 injection, are you?
Absolutely not.
No. But you know that based on what you understand, that in these RZ plays or RZ zones, that you tend to see the higher oil saturations with the lowest porosity.
That would be, by definition, residual oil. Yes.
Yeah. And the reason for that, just to be clear, is because despite the multiple pore volume sweeps and the move to oil wet systems, and because partly you're moving to an oil wet system, you're stripping all the high ends and the oil is becoming more mobile, and the oil that is left after those multiple pore volumes is the oil that's the hardest to reach, right?
Yes.
Yeah. All right, let's see, page 8 here. I'm going to look at this second highlight portion here. The OPS geologic solution continues to follow the resistivity and porosity, while Goodnight water saturation immediately increases to largely above 80% with no defined CO or change in resistivity to support the assertion. And I guess we're talking about the EMSU 746 here, right?
Yes, such as that.
Yes. Okay. I think the questions I had around this, I think we discussed, because I wanted to ask you more about what you understood Dr. Davidson's model to be, and why you thought he might be interpreting changes at those points. But I guess I might ask that question again. Do you have an understanding for what exactly Dr. Davidson's model is and why he's interpreting changes at those points?
I do, because he's interpreting a very small shift in gamma ray at that point.
Right. Okay. And I've asked you about what your understanding was for that gamma ray shift, and I think you've given me what you understand it to be.
I know that there are acoustic sands there. I know that the other indications, like we don't have spectral gamma ray to say what the actual cause of the gamma ray shift is.
Okay. Now I'm going to pull up, I think it's your L26, which addresses this particular log. What time is it? L4. I wonder, Mr. Hearing Officer, this is going to be I think this next section is a little bit more extensive. I would like to not get into it before taking a lunch break. It's a little early. And if it's okay with the commission and parties, I might suggest that we take a break a little early today so that I don't have to interrupt my flow of cross on the next section of my test of this portion of my examination.
Chairman Rosatos. I'm okay with it. Meet back at 1.
That would be an hour
and 20
and 20 minutes. Is
giving an hour and 15. So
fair enough.
Mr.
You need to
Miranda?
take a vote.
Okay.
OCD does not object because I'm happy to eat lunch anytime we're near.
Mr. Moander eats lunch early. Ms. Shaheen.
I would just note that Mr. Burkhead is here today and leaves tomorrow, so we need to finish up with him today.
How much longer, Mr.?
I don't expect to have any problems with that. I think I probably would have, I don't know, an hour at most after lunch. So I don't think it would be a problem. I just don't want to interrupt my line of questioning right now.
Sure. Mr. Moander?
I'm not anticipating crossing this witness unless something comes up and Mr. Rankin's cross-examination.
You keep laughing. Mr. Beck?
No objection.
Thank you. Mr. Suazo?
No objections from pilot.
So I think, Ms. Shaheen, from what I hear, it will be kind of wrapped up for Mr. Burkhead today. Today has been classic. Anything that can go wrong will go wrong. I know. Sorry, Mr. Burkhead. I'm trying not to jinx you. But it seems like we'll probably be able to wrap it up. We'll have a solid 3 hours afterwards, and we could just kind of go through it.
Thank you, Mr. Chair.
Thank you.
And Ms. Hardy, do you have another witness in queue after Mr. Burkhead? Is it Dr. Buckwalter?
Yes, that's
Will
correct.
he be available if we have time this afternoon to
Yeah.
start with him? Okay. All right. Well, all right. Well, we're cutting into our lunch hour already. Let's go off the record and get to the important stuff.